My name is Sheila Fallon, and I'm an attorney at Stanley Law Offices in the department dedicated to workers' compensation. The first question, and I'm going to refer to my notes because I've jotted some down here, is do I even need to hire a lawyer? The important point to remember there is that the insurance companies all have their own lawyers, whether they have an in-house lawyer or they have a team of lawyers from a firm that they hired to represent them. So, if you have a very simple case and you go out of work and they pay your medical bills and you're not out for very long, maybe you don't, maybe you might get away without an attorney. But if your case is sophisticated in any way, or if you're out for any period of time, it would obviously behoove you to hire a lawyer. Again, and the problem with even asking the question is you really don't know what you don't know. Even if I'm a lawyer, and if I had a problem in a different area of the law, I would consult with an attorney. So that is why I would highly recommend retaining an attorney for your workers' compensation case. You should be aware that you do not and should not pay an attorney out of pocket for a consultation or for representing you unless the fee is approved by a workers' compensation law judge. So an attorney cannot gouge you, they cannot overcharge you for representing you in a workers' compensation case, because all fees have to be approved by the New York State workers' compensation law judge. Our consultation, again, is free because we can't charge out of pocket anyway, but we are happy to talk to you about your case on the phone. And, with some clients, if they're not sure if they want to retain an attorney, sometimes we'll say, just call back when you need us again, or when you feel that you are ready to retain an attorney. Another very commonly asked question is, if I hire a lawyer, will that cause my employer to fire me or be mad at me or, cause me real problems? And the truth is that the problems that people have, really, if they're going to have a problem with their employer, is for having a compensation case at all. When we give notice that we're representing you, we give notice to the insurance. We are obligated to give notice to the insurance company and to the workers' compensation board, not to your employer. But again, your employer and the insurance company, they are represented by an attorney. You have every right to be represented by an attorney in your case, so that you make sure that your rights are protected. Another question people often ask is, I'm already being paid compensation, but my checks aren't on time. And can't the insurance company be penalized because they pay my check a week late every week or every time I receive a check? And the answer to that is, if it's an installment payment of compensation, which means, for example, if it's you receive a check every 2 weeks when you're out of work, they can't be penalized unless your check is 25 days late. So that's a long time. That's obviously, it's almost a month. If you think, or if it's so that's a regular check every 2 weeks. If you've gone to a hearing, and whether you're settling your case or you go to a hearing and you're owed back money or a retroactive check, the only way that they can be penalized for a late payment is after the filing date on the notice of decision that you receive in the mail after the hearing, the check is more than 10 calendar days late. So the bottom line is, if you think your check may be late, you should keep a copy of your check and a copy of the envelope that the check comes in, and you could give us to Stanley Law Offices, and we can request a penalty for you if you're due one, or we can advise you whether or not you're entitled to a penalty or not. Do I have to look for work when I'm on workers' compensation? Very often, the insurance company will send you a letter and say, very often, the insurance company will send you a letter and say, where are you looking for work? Send us a list of the jobs you're looking for. And you might not even realize that you're obligated to look for work, and you may not be obligated to look. So that's also an area where really you should rely on an attorney to advise you as to, number one, whether you're even obligated to look for work. Number two, what does that mean? Some people will start looking for work. They might jot down a few jobs a month and think that they're satisfying that obligation, and that is not satisfying the obligation. So it's tricky. It can be very tricky. It's very fact specific depending on what your situation is, what your restrictions are. Also, whether you're still employed by the employer that you were working for when you were hurt. If you're still employed by the employer that you were working for when you were hurt, you don't have to look for work if within your restrictions outside that particular job. If you've lost the job and if you've lost the job, then you may have to look for work within your restrictions. If your doctor, either your doctor's indicated that you can't, that you're less than 100%, or you've gone to a court and the judge said, look, you're less than 100%. So again, it's very specific to your case, and that really can be tricky, and you should consult an attorney if you're not sure, because your payment's going to be stopped, and it's not even your fault. You might not realize that you're not what they call attached to the labor market because you haven't jumped through the right hoops and you didn't even know you were supposed to do it in the first place. Another question people often have is they'll call and say, I'm on workers' comp. I thought everything was fine. And all of a sudden they've stopped my checks and they didn't even tell me. And there must be something you can do about that. If you haven't been to a hearing yet, basically the insurance company can stop your payments if they have a basis to do so without even telling you. You can just all of a sudden your checks will stop one day and unexpectedly. But if you've been to a hearing, and then if someone calls us at that time, we make sure that they have the evidence to support their ongoing payments, and then we request a hearing for them. If you've been to a hearing, the judge will and we get your payments continued at a hearing. The judge will direct that the payments continue, and the judge is directed that the payments continue. They can't stop your payments or reduce your payments without a hearing. So they have to request a hearing. And that brings us to the next question was, I received a notice to see their doctor. Do I have to go? Or I just saw their doctor. Why do I have to go again? If you're on workers' compensation, you're still receiving medical treatment and in need of medical treatment, or you're out of work, they have a right to have you examined by their doctor. So you should go to that appointment. And that very often is the basis for the carrier the insurance company requesting a hearing to reduce your payment. So we have to make sure that you have the medical evidence of your disability and that it is sufficient. And you might think you've been to the doctor and maybe the doctor didn't write down what your degree of or percentage of disability is. And so that's where we come in to make sure if they're not indicating or being specific enough with what your restrictions are or what your degree of disability is, then we write to the doctor and call the doctor and make sure that they fill the forms out correctly. Another question is, when can I settle my case? Basically, there's basically two different ways that you can settle. If you have a limb injury, an arm, hand, finger, foot, we have what you call a schedule loss of use, where the general rule is approximately a year after the injury, or if you have a surgery, a year after the surgery. If you've reached maximum medical improvement, we have you go back to the doctor. We write to the doctor and ask them their opinion on your schedule loss of use, according to the workers' compensation law. The insurance company may have you examined as well, but you're then you may be entitled to an award with medical left open. There's also what they call classification that is complex. They take into consideration not only your physical disability, but what your kind of work you've done in the past, what your education is, your age, and they factor in those considerations when determining what your percentage of permanent impairment and disability is. So that is complex, very complex. It may involve your testimony. Definitely recommend an attorney if you're in that position. But you can settle in. That being said, in either of those, if those findings are made, whether you're given a scheduled loss of use or you're given a loss of wage earning capacity, you may settle your case and waive your medical by Section 32, and that again is complex, and you don't want to undercut yourself or or settle for an amount that is not enough. So again, I would recommend you should consult with an attorney so that you do not. The fees are not large; they're not usually more than 12.5% of whatever. It's based on the work we do, but as a general rule, it's not more than like 12.5% of whatever amount you get. So it's definitely worth getting an attorney to make sure you get the maximum award. Another frequently asked calls we get, frequently asked questions are about medications. There's obviously your doctor has to prescribe your medication, but there's a recent law. It's a drug formulary where there's certain drugs that do not require prior authorization by the insurance company, but there are others that do. And if you have one that the doctor requests and they deny it, the insurance company denies it, the doctor now has to request review of that. And it used to be where the judge would be involved a lot more. We could request a hearing and address the particular medication or issue before the judge. But now, if your doctor won't use the formulary and abide by these guidelines, then there's nothing we can do. But again, we're here to answer your questions because we definitely want to assist and make sure that you get your treatment and recover and be relieved of pain so that you can get back to work and get on with your life and enjoy your life. Often you'll receive in the mail different forms that you don't understand. One of the forms is it's by abbreviation known as a SROI, or a supplemental report of injury. This is a new form only in the last few years, where the carrier will file them from time to time when there's been payments made or to summarize the payments made, and they're very hard to understand. And so again, it's just for your records, but if you have any questions with regard to those, we can help you answer those questions. There's also you will often receive a letter from the insurance company indicating you have to fill a form out or they may stop your checks. That really is not necessarily true. It's called an alive and well check. You really need to speak to an attorney about that, because sometimes it can be a gotcha situation. For example, you don't know that you're supposed to be looking for work because you're not represented and nobody told you to, and they'll ask on the form, are you looking for work? And you'll think, well, no, because I can't do my regular job. But you don't realize that you're actually obligated to look for work because, for example, let's say you no longer work for the employer that you were employed by when you were hurt, but and you're less than 100% disabled, and you don't realize that, yes, you are obligated to look for work. And again, that's why it's so important to have a lawyer, so that the next thing you know, you fill out this form, the insurance company uses it to request a hearing and say, Judge, we want the payment stopped. Here's our proof, our evidence. We're going to now you're filling out a form and they're using that against you to stop your payments. So that's why, again, it's important to consult a lawyer to make sure you don't make an innocent mistake and then suffer for that innocent mistake. Another question that people often ask is, my payments have been reduced. I'm looking for work. I can't afford to live on the amount of money they're receiving. Can I apply for unemployment and workers' compensation? And the answer is yes, you may do that, because if you're partially disabled and you're only getting partial comp and you're ready, willing, and able to work, you just call call unemployment, apply for unemployment, apply online, and tell them that you're only receiving partial workers' compensation. You are entitled to partial unemployment. You're also entitled to your mileage to and from your doctor's appointments, physical therapist appointments, as well as IMEs, the insurance company doctor's appointments. You should keep a record of the mileage. There are forms we can provide to you that where you can keep that, keep your record of your mileage, so we can submit that for you. And also, if possible, use MapQuest or Google Maps or whatever to show proof of the fact that your mileage is correct, that you're putting down, so the carrier doesn't have to double check and make sure that you're not over giving yourself too much mileage to and from the doctor. That helps to attach that. Another question people have is, well, again, we would consult with you about you're looking for work, but keep copies of all applications that you make. Keep a record of anybody you talk to, their names, their telephone numbers, any follow-up that you do on job and your job searches. That's very important. A question, very often we'll have new clients call and say, everything seems to be going okay, and the nurse from the insurance company called me, and they're going to come to my appointment with me to see my doctor. We immediately would call the if we were representing you, we would immediately call the nurse and tell them that they cannot go to attend your appointment with you, because you're under no obligation to have a nurse come into your appointment with you from the insurance company. They are appearing on behalf of the insurance company and not you. Very often they will help you as far as maybe at the beginning help you with getting treatment, but we've had many cases where it does not turn out well, because they'll be pushing you back to work before you and your doctor feel you're ready, or your doctor feels you're ready, and it might put pressure on the doctor. They think they have to release you back to work before you're ready. The bottom line is, you want to consult with an attorney so the attorney can advise you as to whether or not that or any other activity on the part of the insurance company is required of you, or if you have an option to opt out of it. Another question is, what if I have a personal injury case and a workers' compensation case that arise out of the same accident? Is it okay to have to be represented by two different law firms? It's our policy to advise you that you should be represented by the same firm, because there's very complex issues that come up, and we work directly with the attorney that, for example, if there's another attorney representing my client in my office, we work directly with them. We conference cases frequently as to what stage the personal injury case is at versus the workers' comp case. And there are many issues that overlap. So we work, it can be very delicate at times to make sure you get the most money from the workers' comp case and from your personal injury case. And that, it's very, very complex issues. So that's why we're very confident that, because of the number of years we had, not only in representing people with workers' compensation cases, but also with personal injury cases, motor vehicle accidents, labor law cases, slip and falls, dog bites, all kinds of personal injury cases. But the main thing is that we work together so that we make sure that you are covered and that all the little issues, that need to be taken care of, that we can help you and apply our expertise to that particular area. So if there are other dedicated pages on the website which you can refer to, and if you have any questions at all, you should call the office, and you'll speak to any of the attorneys or paralegals that could answer your questions. We'd be happy to do so.